Rules to Reality is a podcast that highlights how regulation shapes or fails to shape our daily lives. I'm speaking to you from Wurundjeri country and would like to pay my respects to elders past and present and any Aboriginal or Torres Strait Islander people listening today. I would also like to acknowledge the ongoing role that colonisation and racist regulation has had on First Nations, but also First Nations resilience and survival in continuing to connect and practice the oldest living culture in the world.
So some of you will naturally be suffering some significant withdrawal mechanisms because you haven't had your Rules to Reality episodes over the last couple of weeks. I apologise. I've been busy writing what's naturally going to be a bestseller. It's a report on best practice regulation in clinical mental health settings. It'll be available at no good bookstores, but it has been keeping me busy. So I wanted to replay an episode with Associate Professor Camilla Nelson on the family law system. I hope you enjoy it.
Thanks so much for being here, Professor Nelson. I'm wondering, are you able to tell us a bit about, what regulation means to you, or why that matters to families or people going through the family law system?
I actually think that one of the most remarkable things about the family law system is that it is almost entirely unregulated. So there are, while there are practices and procedures, I mean, the Family Law Act says that lawyers have to provide prudent advice and settle cases quickly. It doesn't seem to have very much traction. While the court uses single expert witnesses as a pivotal form of deciding a case, the law does not regulate the credentials and practices of those single expert witnesses. While the law will turn to private business enterprises to conduct supervised contact on court orders, it does not regulate the conduct of those private businesses that provide the services. So, for example, just about a year ago, there was a person who started up a child supervision service to make money in the family court. And this person had his own history of domestic abuse convictions and allegations. Okay.
Terrific.
So we're not regulating the conduct of the people that work within the court, and perhaps there's a certain assumption that, this is a superior court, therefore we're inherently accountable. So the lack of regulation is extremely astonishing.
Yes, and I've been fortunate to read your recent book, Broken: Children's Parents in the Family Courts. With your co-author Catharine Lumby, and in that book you detail how the conduct of, you're talking about that lack of regulation and how the conduct of judicial officers or judges, lawyers, even independent children's lawyers who are meant to act in the best interests of a child and represent their views, and even abusers have all gone unchecked. And I mean, I've kind of raised a number of different people there, but I'm just keen if you can let the listeners know what you've seen as the consequences of that lack of regulation.
Yeah, sure. So I think that let's start with independent children's lawyers. Now, independent children's lawyers don't actually work on advocacy principles. Then they don't represent the child's views. They represent the best interests of the child. So they represent what they think is the child's best interest, which may or may not include the child's view. So it's what we call a substitute decision maker model of representation rather than a rights-based form of representation. recently, the state coroner here in New South Wales made an adverse finding against the independent children's lawyer in the case of the murders of Jack and Jennifer Edwards by their father. This was a case in which the children, who were young people, really, said to the independent children's lawyer that they did not wish to see their father because their father had been violent and abusive. The independent children's lawyer, in representing the best interests of those children, I use the inverted commas sign there, went to tell the judge that the children were in danger of losing their relationship with their father forever, that the children's views were probably influenced by the mother. And even though this case eventually was settled between the lawyers, the transcript makes shuddering, it makes shocking reading, the court transcripts in this case, that subsequent to the legal action, the father shot both the children in their home. It's an astonishing case. It's a shocking case. It just demonstrates what's wrong when you are not taking, yes, this is about law and regulation, so it's an advocacy-based, a rights-based approach. The children's views are a component of the children's best interests, even if you are using that substitute decision-maker model. So the coroner made an adverse finding against the lawyer in that case. We don't know what the Legal Services Commissioner will find, because certainly, again, that report will go back to the coroner. It's not something that's necessarily going to be made public. And in fact, most investigations by the Legal Services Commissioner, the Legal Services Commissioner should be regulating the conduct of lawyers. Okay, and including the way they behave and the fees they charge. But it is extremely rare for the Legal Services Commissioner to take any action. So there have been cases, for example, where, again, here in New South Wales, a judge referred the parties at the trial, the parties' lawyers to be investigated by the Legal Services Commissioner. Such was the judge's ire, despair, shock at the conduct of the lawyers in the case. And once again, there was a sense that they found the Legal Services Commissioner said, oh, well, there's no grounds to regulate anything here. So what I think people miss as well when we talk about the justice system and when we talk about the family court, they forget that the legal profession is a profit-centered. It is a private business enterprise. It's incentivized by profit making, and it's in lawyers' interests to say, oh, the client's always right. In fact, the interesting thing about lawyers, when they started deregulating the legal profession in the late 1980s, before then, lawyers, for example, could not advertise. That would probably be the most prominent change or visible change. But since the law profession was deregulated, lawyers have styled themselves more as a business and less as a profession. When I have law students in my class, when I teach them, I have students who actually come and talk about the legal business says this, and I sort of look at them across the lecture theatre and I say, don't your professors tell you that law is a profession? When did law become a business? But of course, people who practice in law practice it as a business to earn an income. And so if you're not talking about law as an industry, as an income generating enterprise, well, quite frankly, you're not talking about the legal system.
Yeah, and it does seem like it's this kind of, yeah, so you're talking about the regulation of behaviour, but then you're also talking about regulation of a market system there that's just gone wild. And one of the things, just going down one of those threads, one of the things you talk about in the book is just the exorbitant, you talk a lot about how it incentivizes further engagement and litigation, and just the exorbitant prices that lawyers are charging, and some of the fees that and the terms and the types of fees that they're charging people, and they're left with no assets at the end of these processes.
Yeah, absolutely. And I think that it's not unusual for those situations to materialize. Now, very recently, the government has issued a report where they have asked the court to regulate or manage the kinds of fees that lawyers are charging in a more systematic way than the court has in the past, because in the past the court just hasn't done anything about it. A judge may have said something snappy at trial. Sometimes when you read judgments, it's shocking that they seem to that there is a sense that that the loss of the complete depletion of assets is blamed on the parents rather than on the billing practices of lawyers, and yet we know from reports, the Productivity Commission report on access to justice, for example, tells us that justice is out of reach for the majority of Australians. That unless you are the bottom 8% who are entitled to legal aid, or you are or you're so rich it really doesn't matter, you can't. Most people cannot afford to go to court. Lawyers, this is, and it's a joke lawyers often make, lawyers couldn't afford to hire lawyers in many senses, although I take that back, some of them can. So yeah, you have a court system in which your top barrister is going to be charging $20,000 a day, and that will be for every day at trial. And they will also want 10 days prep time prior to the trial. So that's pretty much your top end in family law. In other areas of law, barristers can get up to $30,000 a day. If you want to look at the bottom end, you're not going to get spare change from $3,000 a day for a barrister. I know one or two people who sit just under $3,000 a day, but you need a barrister to go to court, and you need to also hire a solicitor before you get a barrister. So not only do you need to pay the barrister's fees, you also need to pay the solicitor's fees. So a solicitor's fee in a private practice is going to range from $350 an hour up to around $650, $750 an hour. And at the top end, I know that there are solicitors charging $12,000 a day for court attendance. That's your once again, it's your top end. In fact, it's the solicitors rather than barristers who make the most money out of the cases that go to court. So, yeah, look, the system is incentivized through profit, and and you really need to look at regulating that. The government, in their recent report, and the court has said that it's going to try and patrol it, has said that, well, in a property matter, a lawyer should no longer be allowed to charge more than 20% of the assets of the family in a property matter. But look, what family can give up 20% of their assets? It's 10. They said 10% for either side, and that's only for a property matter. It's not for children's matter. In children's matters, it's unregulated, and also in the the recent government report, the number of exceptions to those bills, like the 20% cost cap for the family, everything that is not involved with the pointy end of litigation, that is sort of interim hearings and trials. So anything to mediation or arbitration or any of those sorts of processes are exceptions to the cost cap. So, you sort of read these regulations and these proposals for regulations, and you sort of think, well, what's going to happen in 10 years' time with this new set of regulations? Because terribly cynical. Are these new sets of regulations actually offering lawyers a place to hide costs? I.e., if you say it was a pre-trial mediation, arbitration, or something like this, I don't have to declare. It's an exemption. So you don't know. With the funny and I think really interesting thing about regulation, if you're a bit of a nerd.
Well, you're on the right podcast, Camilla.
Is the way it shapes human behaviour, or does not shape human behaviour. That sometimes there might be a good intention in the regulation, but human behaviour changes in a way to get around it. So it's kind of interesting, and yet it takes a long time and then a lot of information gathering to see, well, what effect did that new raft of regulations actually have. I'm concerned that despite this cap in property matters, that we're not going to see, that we're not really going to see change. And I'm also concerned, well, who's going to patrol this? Who's going to patrol these regulations? Because, judges haven't regulated these things, haven't patrolled, rather, these things in the past. So why do we expect they will be suddenly controlled in the future? I'm not holding my breath.
You're identifying there that obviously the way regulation can shape or fail to shape people's lives, and definitely that market-based system is creating quite perverse incentives. One of the other, from reading your book, one of the other ways in which that whole market or system regulates behaviour is the way in which it enmeshes with abuse. My reflection, sort of reading, you talk about litigation abuse, which some listeners might or might not be aware of. I'm just interested, how does it, it seems to regulate the lives of women and children in a really negative way, based on the way it's playing out now. What's your reflections?
Yeah, absolutely. I mean, look, there are violent perpetrators and abusers who manipulate the legal system in order to coerce and control women and children. The way the law is written, again, it enables this. You take a simple case about contact with a child. If a mother fails to turn up with a child for the court-mandated contact, or the child doesn't make the phone call at 9 o'clock in the morning or at 8 o'clock at night, or whatever the court had ordered, the only thing the mother has to stop the other party from taking her to court and dragging her back through court is what is called reasonable excuse. Okay, so put the shoe on the other foot. The father who does not answer the phone at 8:30 at night, or who does not turn up to contact with the child, gets off scot-free. There's no sanction against the father for not showing up, but the mother's behaviour at the greatest extreme can be criminalised. Okay, and we forget that there are what we call them quasi-criminal penalties in the family law, but you can be jailed for this sort of issues around contempt and those sorts of things. So the family court has the highest number of what the law calls vexatious litigants. In fact, it has more vexatious litigants than the entirety of every other superior court combined. Vexatious litigants, to use the legal terminology, they're people who habitually take other people to court. Often a vexatious litigant, or in this case an abusive perpetrator, well, there's not much difference between an abusive perpetrator and a vexatious litigant. Okay, because what you find in the family court is the perpetrator is taking the other party to court in order to exert control as a form of abuse, in order particularly to damage them economically, financially, and to impose distress on the other side. So in a sense that the law allows the perpetrator to continue to abuse the other party through different means. Okay. And it's interesting that the other thing is that in 40% of family law cases, one or both parties will be self-represented. Okay, so there you can have a perpetrator who is conducting his own case in the court. There are also cases where the perpetrator is representing themselves and the other party who doesn't have enough money to get a lawyer then has to defend themselves against the perpetrator to the satisfaction of the court. Okay, the system, it incentivizes abuse. It also enables abuse, and it does seem that judges simply, not all judges, okay, not all judges. There are some good judges, but there are
there'll be a hashtag not all judges.
Hashtag not all judges. Hashtag not all lawyers. They don't see it. One of the cases in my book involved a woman who was taken to court because her former partner did not want her, disagreed with the fact that she'd allowed the youngest child to participate in a music audition. Yes. Okay. And she received a prison sentence, which the judge agreed to suspend. It's astonishing, but these things happen in the family court. I mean, subsequently, this case was overturned by the full court, by a majority of the full court. Okay, but the thing is, the harm, the distress, and the financial disadvantage. Okay, the woman has already, the impact is achieved because the woman is financially disadvantaged and harmed and distressed. And indeed, let's not lose sight of the child because, in this case, the child had actually won a music scholarship and did nobody ask? How hard did the child need to work to get a music scholarship? Was this something the child wanted?
Yeah.
The whole, not the first case and not on appeal, was the child considered? Because it was, it was a contravention, what you call a contravention hearing, and the child's best interest is not a factor in considering contravention. But yet we're told that the paramount principle of the law is the child's best interest. How do we get there? It's really quite a frightening culture. It's a culture that silences children. It marginalizes children. And I think that it's in the disregard for children that's where the most serious problems lie, I think.
Yeah, and I mean, I really encourage people to go out and buy and read the book. And there were, my sense reading the book was the system makes women and children profoundly unsafe. Of course, I'm sure at times it makes fathers unsafe, but really the strongest themes were mothers and children becoming unsafe, and the just the hypervigilance you must be succumbing to as a mother going through this system where you're, both the father and the court is like this surveillance machine, just following you, and these mothers who are just so scared of the the phone ringing. I think you might, in the book you spoke about a woman who just took a phone call and received some bad news and just dropped to her feet.
It's because going back to what I was saying earlier about reasonable excuse, that as the mother, if the child is living with you, the child doesn't make the phone call on time for some lots of things could happen. The child could be sick, the child could be late from school, the child could be this, we all live lives. But the court orders the 6 o'clock phone call or the 6:15 phone call to provide what's called reasonable excuse to the court. Okay, this means that the mother has to create a written log, of any the reason why the child was 1 minute late or 5 minutes late or 15 minutes late, or the call was not made that day, but they made up the call on the Thursday afterwards, and all of this sort of stuff. So you're logging and logging and logging to prove that you have a reasonable excuse. Because the thing is, if you get taken to court 6 months down the track, by an abusive former partner, you will need to demonstrate to the court that 6 months ago you had this excuse, 10 months ago you had this excuse, 3 weeks ago you had this excuse. And if you don't meticulously detail these things, then you've not got a case. And then you could, contravention of a court order potentially carries jail time. It carries either a fine or it carries jail time. I mean, these things are treated seriously by the court, and treated, actually, take all that back, in the wrong way. They're treated in the wrong way by the court. And it is frightening that, and I'm thinking of another case that I think it's the one that you're referring to when you talked about the woman collapsing. And that was a serious domestic violence case as well, where there had been serial family violence orders, including one long-range order that had extended 3 years. But despite that family violence order, and you don't get a 3-year family violence order, off the bat. I mean, that's something that you require considerable evidence to have, and yet you know the family court still orders conduct, and the family court
that is sick.
Fails to perceive what is happening. It doesn't. Yes, it is about this micromanagement of women and children in ways that are macabre. I sometimes think unless you're actually there in the courtroom watching these proceedings, no one would believe you.
Yeah.
And yet, you know, the reason I wrote the book in the way I did, you know, there were legal, you know, you can either go with interviews or you can go usually with the court judgments. And I wanted to go with the court's own words because then, you know, this is what the court did. This is what the court said. Okay, there's no ambiguity around, oh, she's just, this is the woman was mentally unstable, which is the staple of arguments. That these are things that the court did. These are things that judges thought were the right thing to do. I don't know how they got there, but they did. And so, you know, telling the stories in the court's words, I think is an important part of the book because it's about accountability. I don't think that, you know, this is what you did, this is what you said. It's less, it can't be dismissed as in ways that other court reporting, I think, tends to be dismissed. Because we've had brilliant journalists like Jess Hill who've done brilliant work. You know, there's some great journalists at the ABC producing brilliant work. And you sort of think when you read some of these stories as they come out, well, you know, they've just shown you what's wrong. They've just shown you what's wrong with the system. They've done their job. They've held up the mirror to the system. And yet somehow nothing changes.
No.
So it's, it is, it's something that I think that people need to be aware of and to, to keep it as an issue or to make it as an issue.
Yeah, absolutely. And we'll move towards how we can do that, and some changes that could be made in a second. But I just wanted to go down or take us back, go off track a little bit, but just take us back to the fact that, you know, reading through your book, I learned that it wasn't meant to be like this. When the family court was set up in the 1970s, it was during the Whitlam era, if I'm not, or around that era, that period of time, and it had brought ambitions to be something different, certainly different to what it is today. But there's been lots of reforms, quote unquote, in that intervening period, which kind of get us to where we are now. I was just wondering if you could explain some of that.
Look, when the Family Law Act was passed by the Whitlam government, and in fact, when the family court was set up as an institution, it was in fact arguably the best family law system in the Western world. It was the most progressive. In 1975, children had more rights under family law than they do today. For example, back in 1975, and Lionel Murphy was very clear about this, you know, the court could not make orders against the wishes of a child of 14 years and over unless there were extraordinary circumstances, because, you know, things always come up. Also, a child, a mature child or a young person could go to court and ask for the orders to be discharged, okay, because we don't need to regulate the conduct of people who are literally almost an adult. There was a clear understanding that children have a right to grow, and as part of their growth, they grow into autonomy, for example. That was all junked in the 1980s. There were other things that were in the Family Law Act. In fact, you have to go all the way back to one of the things that flies out is money and property. I mean, honestly, reading the Senate debates is sometimes feels like reading the Married Women's Property Act in the 19th century, because you sort of go, oh my gosh, we really had no rights before they brought those laws in. This idea, oh yes, marital property will be split. There's a famous anecdote from a lawyer at the time in the early days of the court, and he's summing up what his male clients say to him, and that is, are you telling me the law says that I have to pay my wife for the pleasure of cooking my dinner? And yeah, I know. And the lawyer says, yes, actually, that's what the law says. So it was progressive. Okay, we've gone backwards. We've gone backwards. We've not gone forwards. I think there were unforeseen things. I think that as you fast forward to the 80s, particularly with the family court bombings, you see a huge clawback by men's rights activists, where, and you read the newspapers at the time, and it seems that...
Could you explain what those were? Like, a lot of people won't know what those bombings were.
Yeah, the family court bombings occurred in Sydney through the 1980s. So a family court judge was killed, assassinated on his doorstep, shot dead, while his wife and children were in the house in the middle of dinner. Another judge had his house bombed while his children were in it. And it was very lucky that the children escaped without injury. Another judge was a bomb was wired to the front door, but the judge didn't answer. His wife did, and the wife was killed. And it goes on. There was a bombing in a church hall where a member of the congregation was killed. Now, people at the time, they knew that murder is wrong, but instead of condemning the murderer, there was this whole idea in the newspapers of the period, what's wrong with the family court that would drive a man to such extremes? And this is literally the subtext of every article that appears. There was the Dean of St Andrew's Cathedral here, which is in Sydney, gave a sermon saying that good might come out of evil if they get rid of the court. So, like, hello, this was the morning after the judge's wife had been murdered.
Very Old Testament.
Yeah, it's astonishing. So in some senses, it's kind of like domestic violence writ large in the way that kind of victim blaming rhetoric that we have had around domestic abuse and femicide and those sorts of things. But here the victim being blamed is the family court, with a female Chief Justice, Elizabeth Evatt, and all of those sorts of things. So the government turned around, wrote to all of the men's rights groups and said, what can we do to help? Okay, so
would it be fair if people, just fast forwarding, I'll sorry to interrupt, but that kind of sounds like terrorism, using political violence to achieve political means to me.
Absolutely, and I think that and you're not the only person, because the Leonard Warwick, who's the family court bomber, they never were able to charge him until only a few years ago. Okay, and when the judgment finally came down in the Supreme Court here in New South Wales only a few years ago, the judge did single it out as an act of political terrorism. Okay, there was an acknowledgement in the judgment that this is what it was. Okay, but back at the time, it seemed that it was fine to respond to what is an act of terrorism and has now been defined as such by the court. by saying, by taking the bomber's message on board, what can we do to help? And then you have this process of clawing back, that they're through the turn of the century, this present century, a new sort of doctrine of the indissolubility of families was invented, or the indissolubility of parenting. It was invented, which meant that as it translated into law, courts compelled couples to stay together. They compelled contact, even in cases of abuse, and they still do. This is the thing. But they bring in supervised contact if the parent is demonstrated to be too dangerous to have unsupervised contact. I know they didn't. Well, what impact does that have on a child? The 70s had a different approach in that they had this idea that the parties would go their separate ways. It was a different kind of approach, but it was also naive in some ways. People thought that if couples could get divorced quickly and easily, that domestic violence would disappear. And of course it hasn't. What has happened is that the vast majority, 97% of separating parents, do not go to court in this country. The cases that end up in court, though, that 3% of cases that end up in court are overwhelmingly domestic abuse cases. Okay, up to 85% domestic abuse, more than half with physical violence and serious safety concerns or serious child abuse. So we have a law that's written for a kind of the Leave It to Beaver family, not a law that is safeguarding the vulnerable children and vulnerable families in the situation that it should be looking at. That is the 3% of cases that are overwhelmingly issues driven by domestic abuse. Yeah.
And there's just, going through your book, the way in which those reforms over the last 30 or 40 years have created so many leverage points for abusers to use that system to create control.
Because they've widened the areas of dispute. They've made more areas of dispute, more grounds on which you can litigate rather than less grounds. And the laws are seriously gender biased.
It seems to me like it's a classic case of neutrally appearing laws clearly favouring one. Even maybe that is not even neutrally appearing. You might know better than me, but things that on the face of it look neutral but have just radically different outcomes for one party or one group.
Absolutely, and it's I think that in a sense that the law likes to think it's gender blind, it's very obvious when there are interim hearings. Separating parents go through a series of court events as they progress to final trial, and most cases don't progress to final trial unless they're profoundly serious, or they have money, or there's a lot of reasons why cases don't progress to trial. But it does incentivize the wrong kind of It inflames and escalates the behaviour. The adversarial system, report after report, has shown that the adversarial system, the idea of this sort of the applicant and the respondent, or in criminal trials, the prosecution and the defence, it's incredibly reductive in the way that it deals with family dynamics, and in fact, it's not capable of dealing with with the sort of human relationships, because it reduces everything to guilty and innocent. And that's a sort of Back to the Future point, because when Whitlam and Murphy brought in the Act, it was to get rid of fault. Okay, it's no fault divorce. And yet where we are is we're back at fault, we're back at blame, and we're back at this guilty and innocent sort of reductive, this kind of reductive approach. So yeah, it is. I do think that we've gone backwards in a lot of ways. Although certainly I don't think that everything was. I'd never say that everything was rosy back in the 70s, because women didn't have things like economic equality. They had theoretically equal wages, but practically not. But in so many ways, we've gone backwards, and one of the real shocks, I think, in my recent work is particularly backwards on children's rights.
Yeah, absolutely. And in the next podcast, we'll be talking to a young person who talks about their experience. But Camilla and Catharine have done a wonderful job representing kind of the second half of the book. They talk a lot about the experiences of young people and how they're marginalised, silenced, and made unsafe, seen as unreliable witnesses. But I'll leave a lot of those questions for the young person. But I recommend you read the book. So you've canvassed, I guess, the trajectory of how we've come to now, and in some ways we have been going in the wrong direction. What are some, maybe you can say they're policy, maybe they're conversational changes we need to make, but what are some of the changes that we need to make the system safer and better for everyone, but in particular for mothers and children?
I think the first thing that we need to do is centre the family law debate on children's rights. I actually think that fundamentally the worst aspects of the debate, where the debate is at, is that it's always this polarized debate between sort of men's rights activists and, all these nasty feminists, all these crazy women. What nobody seems to be able to see is the child in the situation. The family law debate needs to centre the lived experience of children and the lived experience of domestic abuse survivors in order to understand what's wrong with the system, which is also why there's a part of the Family Law Act called Section 121, which means that a party who's been through court may not speak, or may not be identified. But what this does is that it effectively silences lived experience. It silences children's experiences, it silences victims' experiences. And it also means that the law is separated from lived experience of the law. So there's no feedback here. Okay, the law doesn't know what happens to the children whose in alleged best interests it's acted. Okay, it's blind to this, and there are heavy penalties in a sense that when Section 121 was brought in by the Whitlam government, it was very much aimed at the kind of the tabloid reporting that surrounded divorce at the time, where, the Sunday tabloids would have these sort of lurid discussions of, because you needed grounds, adultery or cruelty or something like that. So there'd be sort of lurid sensationalist reporting, particularly if there was a famous celebrity who was getting divorced. And so they said no more of that. Okay. But the thing is, it no longer, Section 121, I think, is no longer protecting the children and the parties that the Whitlam government sought to protect by bringing it in. It's protecting the court. It's preventing people from talking about their lived experience, or it's preventing people from speaking truth to power.
Yeah, absolutely. And looking through those laws, and it's not just the Family Law Act, but it's various other laws at the state level, family law being Commonwealth. It's this complex web or just gag orders that young people have to, and mothers and other parents as well have to navigate to tell their story, and it just excludes 99% of people, doesn't it?
Yeah, absolutely. And it profoundly shapes the kinds of stories that journalists can write, for example, the kinds of stories that the media can report. It leads to, some things like sub judice contempt are, legitimate. I mean, everyone has a right to fair trial and things like that. But you also need to look at the ways in which it shapes, say, reports of domestic violence. Because you're doing court reporting as a journalist, you have to focus on the facts in front of you. You're not allowed to say, oh, well, this person has a whole string of domestic violence convictions, because that's sub judice. So, and while that is legitimate, I mean, in that instance, I mean, it does shape the story that gets told. Go to the family court, okay, and the lack of centering the experience of both parents and survivors and of children means that these families get pathologized in the media. It means that what we read about in the newspapers, or in fact what goes on trial in the courtroom, is often a stereotype. It is not the rounded individual. And because children, particularly because children are not permitted to have their views directly presented to the court, only their best interests. I think that as children are stereotyped in the trial situation just as much as women, perhaps even and more, because profoundly what the court decides will shape the child's life. The mother will not need to go back to the violent father, but the child will be forced to.
It just completely flies in the face of any logic that you think you could make, significant life decisions about someone without hearing from them, and it also just fails to see young people as themselves domestic violence survivors. It's often treats them more as property than survivors themselves as well.
Absolutely. And of course, historically, the law has treated children as property. I mean, that's not just talking about stereotypes, that's actually talking about the way the law worked. And a lot of that residual kind of terminology is still, the Act at a couple of points still talks about control of the child, and this sort of, which is leftover terminology from the 19th century and from it's the legacy. So centering the child's experience, I think, is incredibly important, which is why it's great to hear about the podcast that you're going to be doing next week.
Yeah, thank you. Well, so you've and we'll hear the same question and answer from the young person next week. But people have listened to you today. They've heard about how the family law system, it's a system that's kind of it was intended to do one thing at its beginning. It's doing a very different thing right now, in that it's controlling women, it's making women and children unsafe, and it's it's a bit of a Wild West situation out there. What's one thing that you want a listener today to go away and do after hearing you talk today?
I think the one thing you can do that I would dramatically change many things in the courts and in the law would be to write to your local MP and write to the Attorney General and tell them to recognise the Convention on the Rights of the Child in Family Law. Australia is a signatory to the Convention on the Rights of the Child. It was signed as a binding convention in 1990, and yet those rights have never been extended to children in family law proceedings. So the one thing that I think would make a huge difference, because everything else would follow from a recognition of children's rights. So yeah, write to your MP, write to the Attorney General, and tell them to recognise the convention for the purpose of family law.
Thank you so much, Camilla.
Okay, thanks a lot, Simon. Thanks for having me.